Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Now, we're talking about adjusting under the U and whether family members can and what's required. Well, as stated in the prior video, in order for the family members to adjust, they do have to prove extreme hardship, and that's not easy to prove. So how can you do that? Well, if the family relative is in the U.S., the principal must demonstrate that removal of the family member would result in a degree of hardship beyond that typically associated with the removal. Now, what factors can you look at in order to determine that? Well, there's the nature and extent of physical or mental abuse suffered by the U visa holder, the impact of loss of access to the U.S. courts and criminal justice system, likelihood the perpetrator's families, friends, and others in the home country would harm the applicant or her children, the applicant's needs for social, medical, mental health, or other supportive services for victims of crimes that are unavailable or not reasonably accessible in the home country. If the particular incident here involves domestic violence, whether home country's laws or social practices would punish the applicant or her children because they left an abusive household, the ability to travel to the home country and receive protection once there, and the age of the applicant at the time and entry of adjustment. So, as you can see, there are a lot of factors that can be considered as to showing and proving the hardship. It's actually quite a bit broader than in other areas of immigration law. So you get all that together, make some good declarations, affidavits, get an attorney that knows what they're doing, and you'll have a lot better chance of having a derivative family member be granted the U visa.